Good afternoon. Our Assistant Registry Manager has talked about the points to note for applicants or holders for TCSP licenses. In this section, I will highlight the key requirements on TCSP licensees set out in Schedule 2 of the Anti-Money Laundering and Counter-Terrorist Financing Ordinance, CAP 615, the ELMO. The requirements are that the customer due diligence, CDD, and record-keeping requirements. These requirements are an integral part of any effective anti-money laundering and counter-terrorist financing regime and are essential to combating money laundering and thereby ensuring the integrity of our financial system. As introduced by Ms. Leung a moment ago, this registry has published 3 sets of guidelines, and one of them is the Guideline on Compliance of Anti-Money Laundering and Counter-Terrorist Financing Requirements for Trust or Company Service Providers. To give guidance to TCSP licensees on the relevant statutory requirements in relation to anti-money laundering and counter-terrorist financing. So, when should customer due diligence CDD be carried out? TCSP licensees, when carry out a transaction concerning a trust or company service for clients by way of business, are required to carry out CDD measures under the ELMO. As shown on the slide, pursuant to Section 3 of Schedule 2 to the ELMO, TCSP licensees must apply CDD when, number 1, before establishing a business relationship with a customer. That is, for example, before they act as a company secretary for a new customer. Second, before carrying out for the customer an occasional transaction that involves $120,000 or more. Number 3, when the TCSP licensee suspects that the customer or the customer's account is involved in money laundering or terrorist financing. And number 4, when the TCSP licensee doubts the veracity or the adequacy of any information previously obtained during the CDD process. This is the documents obtained for the purpose of identifying the customer or for the purpose of verifying the customer's identity. As required under Section 3, Subsection 4 of Schedule 2, if these requirements are not complied with, the licensee must not establish a business relationship or must not carry out the occasional transaction with that customer. If a business relationship has already been established, the licensee must then terminate the business relationship as soon as reasonably practicable. So now we know when to carry out the CDD measures, but what are the measures that are applicable to a TCSP licensee? The CDD measures applicable to a TCSP licensee under Section 2 of Schedule 2 to the ELMO are shown on this slide. First, the licensee must identify the customer and verify the customer's identity. Second, he also must identify the beneficial owner and taking reasonable measures to verify the beneficial owner's identity. In this regard, I would like to draw your attention to the legislative amendments in relation to the definition of beneficial owner in relation to a trust under the ELMO that has taken effect in June last year. As explained in the Legislative Council brief, the objective of amending the definition of beneficial owner in relation to a trust under the ELMO is to align it with that of controlling person under the Inland Revenue Ordinance, which implements the Common Reporting Standard proclamated by the Organization for Economic Cooperation and Development. The amended definition of beneficial owner in relation to a trust under the ELMO is also in line with the FATF's recommendations and other jurisdictions that have already implemented these international standards. A beneficial owner in relation to a trust after the amendment also includes trustees and settlers. For the full text of the amended definition, please refer to Section 1 of Schedule 2 to the envelope and the text box above paragraph 4 in the Appendix D of the AML guideline. So let's go back to the third CDD measure that is applicable to a TCSP licensee. The TCSP licensee should obtain the information on the purpose and also the intended nature of the business relationship. And fourthly, he also must identify the person purporting to act on behalf of a customer and taking reasonable measures to verify the person's identity and verify the person's authority to act on behalf of that customers. For more details of the CDD measures, you may refer to paragraph 5.2 to 5.3 of the AML guideline. Licensees who are in doubt about the information and documents that should be obtained for identifying and verifying different types of clients and their beneficial owners may refer to the various appendices of the AML guidelines. These appendices set out the information and documents that should be obtained for identifying and verifying different types of customers and also their beneficial owners. Licensees should always check whether these information and documents listed out in the applicable appendices have been obtained with performing CDD measures. So to better illustrate the requirements, we have now here a case example of a common transaction for a company service provider, that is, to act as the company secretary for a company X. In this example, company X is the customer, and company X is a corporation. So the CDD measures applicable would be, first, to identify and verify the corporation, company X, and to obtain the information and documents in accordance with Appendix B of the AML guideline, which is applicable when the customer is a corporation. Documents to be obtained include a copy of the certificates of incorporation of Company X, its articles of association, the details of the ownership and control structure of Company X, and a list showing all directors of Company X. Next, the licensee should also identify the beneficial owner of the customer, that is Company X, and take reasonable measures to verify the beneficial owner's identity. As the beneficial owner of a corporate customer is an individual, licensees should collect the information and documents set out in Appendix A of the AML guideline, such as to obtain a copy of the beneficial owner's Hong Kong identity card. Where simple due diligence (SDD) applies, the TCSP licensee is not required to identify and verify the beneficial owner. Under Section 4, Subsection 3 of Schedule 2 to the MLO, customers to whom SDD apply may include, amongst others, a financial institution or a listed corporation. For more details on SDD, please refer to paragraphs 5.22 to 5.24 of the AML guideline. If the customer is a new customer, licensee should carry out CDD measures before establishing the business relationship. That is, before acting as the corporate secretary, company secretary of Company X. But if the customer is an existing customer, then CDD measures should still be carried out as set out on the second page of my slide and under Section 3 of Schedule 2. For example, when carrying out an occasional transaction involving $120,000 or above. If the customer is a pre-existing customer, that is, customers with whom the business relationship was established before the 1st of March 2018, CDD measures should be carried out when there are triggering events. For example, where a transaction which is unusual or suspicious, and when the licensee suspects that the customer is involved in money laundering or terrorist terrace financing. For details, please refer to the text box before paragraph 5.3 of the AML guideline. Please don't forget that where a person purporting to act on behalf of the customer, that person's identity has to be identified and verified as well. Licensees should obtain written authority, including board resolution or a similar written authority, in case the customers are corporations, to verify that individual purporting to represent that customers is authorized to do so. Subject to the requirements set out in Section 18 of Schedule 2 to the MLO, licensees may carry out CDD measures required under the MLO by means of an intermediary specified in Section 18, Subsection 3 of Schedule 2. Please note that the conditions under Section 18, Subsection 1 of Schedule 2 for reliance on intermediaries to carry out CDD measures includes that the intermediary needs to give consent in writing to be your intermediary. And the licensee must also be satisfied that the intermediary will provide copies of the documents, data, or information obtained by the intermediary in the course of carrying out the CDD measures without delay when the licensee makes a request for the same. More importantly, even if the licensee has carried out the CDD measures through an intermediary, the ultimate responsibility for ensuring that the CDD measures carried out are met with the statutory requirements remains with the licensee itself. Specified intermediaries in Hong Kong are listed out in Section 18, Subsection 3, Subsection A and B of Schedule 2. As shown on this slide, they are accounting professionals, estate agents, legal professionals, and TCSP licensees, on the condition that they are able to satisfy the licensee that they have adequate procedures in place to prevent money laundering and terrorist financing. Another category of specified intermediaries is the financial institutions, and they are licensed corporations, authorized insurers, licensed individual insurance agents, licensed insurance agencies, or licensed insurance brokers company. For the requirements on specified intermediaries in equivalent jurisdictions, you may refer to Section 18, Subsection 3, Subsection C of Schedule 2 to the MLO. As shown on this slide, the intermediaries must be subject to CDD and record-keeping requirements similar to those under the MLO and are regulated by the relevant authority in that jurisdiction. Therefore, it is not the case that any unregulated entity can carry out CDD measures for a TCSP licensee as an intermediary specified under the MLO. For details, please refer to paragraphs 5.53, 5.53 to 5.60 of the AML guideline and the text box following the paragraphs. We have also included a Q&A on our website in relation to carrying out CDD measures through an intermediary. Interested licensees may look up the FAQs under the topic of customer due diligence. So after a business relationship is established with a customer, licensees are required under Section 5 of Schedule 2 to the MLO to continue to monitor the business relationship, no matter the customer is a new or a pre-existing customer, including by reviewing from time to time documents, data, and information relating to that customer obtained during the CDD process, in order to ensure that those information and documents are still up to date and relevant. Of course, licensees should also scrutinize the transactions of the customer to ensure that they are consistent with the licensee's knowledge of that customer and its business, risk profile, and source of funds. And lastly, licensees should also identify transactions that are complex, unusually large, or of an unusual pattern, and have no apparent economic or lawful purpose, and examine the backgrounds and the purpose of these transactions, and setting out its findings in writing. At times, TCSP licensees will need to take additional measures or enhance customer due diligence, called EDD. Situations in which TCSPs are required to take additional measures or EDD are shown on this slide. Firstly, where the customer is not physically present for identification purposes. Secondly, where the customer or the beneficial owner of the customer is a politically exposed person. And thirdly, in any situation specified by the registry in a notice given to the TCSP licensees, and in any situation that by its nature may present a high risk of money laundering or terrorist financing. For example, establishing business relationships and conducting transactions with persons from jurisdictions in which FATF has requested the imposition of more stringent or enhanced measures. In these situations, licensees must take additional measures or enhance due diligence in order to mitigate the high risk brought by these circumstances. For the requirements, you may refer to sections 9, 10, and 15 of Schedule 2 to the ELM. Legislative amendments have been made and effective from June last year in relation to politically exposed persons, PEPs, to implement the FATF's recommendations and relevant FATF guidance. As you can see on this slide, People's Republic of China and the definition of PEP under Schedule 2 is now replaced by Hong Kong. With these amendments, enhanced CDD measures and under Sections 10, Subsection 1 and 2, and enhanced ongoing monitoring under Section 5, Subsection 3b of Schedule 2 to the ELM applies not only to a PEP from a place outside China, but also a PEP from other parts of China outside Hong Kong. Secondly, a definition of former PEP is added to Section 1 of Part 1 of Schedule 2 to the ELM, which is set out on this slide. A former PEP means an individual who has been, but is not currently entrusted with a prominent public function in a place outside Hong Kong, and also a spouse, a partner, a child, or a parent of that individual, or a spouse or a partner of the individual's child, or a close associate of that individual. So basically, a former PEP means a person who has been a PEP but no longer entrusted with that prominent public function. Sections 5 and 10 of Schedule 2 to the ELM are also amended. As you can see on this slide and the next, Sections 10, Subsection 3, and Sections 5, Subsection 5 are added, so that the enhanced CDD under Section 10 and enhanced ongoing monitoring under Section 5 of Schedule 2 may not be required for a former PEP who is no longer entrusted with the prominent public function. If a licensee is satisfied that the former PEP does not represent a high risk of money laundering or terrorist financing based on an appropriate risk assessment, licensees are allowed to take a risk-sensitive approach in determining if enhanced measures need to be applied. Please refer to paragraphs 5.33 to 5.44 of the AML guideline for further guidance on PEPs, including the definitions of different types of PEPs, and they are the non-Hong Kong PEPs, former non-Hong Kong PEPs, Hong Kong PEPs, international organization PEPs, and the CDD measures for various types of PEPs, and also the treatments of different types of former PEPs. In addition to complying with the CDD and ongoing measures, ongoing monitoring requirements. Licensees are required to take additional measures under Section 9 of Schedule 2 to the MLAW when customers are not physically present for identification purposes. For example, they would need to take supplementary measures to verify the information relating to the customer that you have obtained. Licensees should consider to mitigate the money laundering and terrorist financing risk by obtaining copies of documents that have been certified by a suitable certifier. Please refer to Section 9 of Schedule 2 to the MO for the requirements and paragraphs 5.29 to 5.32 and the text box underneath for further guidance. Also, in monitoring the business relationship with that customer, the licensee should also take additional measures to compensate for any money laundering or terrorist financing risk that may have caused by the fact that the customer has not been physically present for identification purposes. Please refer to Section 5, Subsection 3, Subsection A, and Subsection 4 of Schedule 2 to the MLAW and paragraph 6.6 of the AML guideline for further details. We also have posted a Q&A on CDD measures to take regarding the situation when a customer of a TCSP licensee is not physically present for identification purposes. Please refer to the FAQs under the topic of customer due diligence. With effect from the 1st of June 2023, the MLAW allows the use of a recognized digital identification system as a reliable and independent source of documents, data, or information for conducting CDD when they carry out trust or company service business. Amendments have been made to Sections 5 and Section 9 of Schedule 2 to the MLAW to cater for this change. As you can see on this slide and the next, Sections 9, Subsection 2, and Section 5, Subsection 4 are added. After the amendment, if the CDD requirements are met, using a recognized digital identification system, that is, where the licensee has carried out the measure referred in Section 2, Subsection 1, Subsection A of Schedule 2, in relation to a customer on the basis of data or information provided by a recognized digital identification system, then the enhanced CDD measures under Section 9, Subsection 1, and also the enhanced ongoing monitoring under Section 5, Subsection 3, Subsection A of Schedule 2 would no longer be required. This change is in line with the FATF's acceptance of digital identification system as an effective means to lower the money laundering or financing risk associated with a customer not physically present. One may wonder, what exactly is a recognized digital identification system? Recognized digital identification system means, in relation to a TCSP licensee, a digital identification system that is reliable and independent source recognized by the registrar of companies. We have posted on our website a FAQ under the topic Digital Identification System to inform all TCSP licensees that the registrar recognizes IAMSmart, developed and operated by the Hong Kong SAR government, as a digital identification system that can be used for identity identification and verification of natural persons. The other key requirements that a TCSP licensee should be aware of is the record-keeping requirement under Section 20 of Schedule 2 to the MLAW. The key requirements for the records of transaction and the records of customers to be kept and the duration of which to keeping these documents and records are set out on this slide. And I think you should all be very familiar with them. Basically, it is for at least 5 years after the completion of a transaction or 5 years after the end of your business relationship with a customer. Do not worry if the records are not kept in hard copy, because Section 21 of Schedule 2 to the MLAW allows records to be kept in a form of computer database. For more details, you can refer to Chapter 9 of the AML guidelines. Legislative amendments have also been made to expressly state that the 5-year record-keeping period also applies to occasional transactions. Records for occasional transactions should also be kept for a period of at least 5 years, beginning from the date on which the occasional transaction is completed. Apart from the requirements under the MLAW, licensees should also be aware of the other anti-money laundering and counter-terrorist financing statutory requirements. In relation to financial sanction, a person is prohibited by the relevant regulation under the UN Sanctions Ordinance, Cap 537, to make available or to deal with economic assets of individuals or entities and designated by the UN Security Council, as well as individuals or entities acting on behalf of or at the direction of or owned or controlled by designated individuals and entities. The term economic asset means any funds or other financial assets or economic resources. The most up-to-date list of sanctioned persons and entities are available online. For terrorist financing, the UN Anti-Terrorism Measures Ordinance, Cap 757, UNAMO, criminalize the provision or collection of property and making any property or financial or related services available to terrorists or terrorist associates. As you can see on this slide, UNAMO prohibits, by Section 7, a person from providing or collecting any property for use to commit terrorist acts, and by Section 8, from making any property or financial or related services available to a terrorist or terrorist associate, or collect property or solicit financial service for the benefits of terrorist or terrorist associates. Also, by Section 9, from dealing with any specified terrorist property. And for Section 11L, from providing or collecting property to finance the travel of a person between states for the purpose of the preparation, planning, or participation of terrorist acts, or the provision of receiving terrorist training, whether or not the property is actually so used. TCSP licensees are reminded not to have any business relationships with any sanctioned individuals or entities, or any terrorists or terrorist associates, as defined under the UNAMO. For more details, please refer to Chapter 8 of the AML guideline. At the UN level, to combat financing of proliferation of weapons of mass destruction known as PF, the UN Security Council has implemented sanctions against North Korea. Such targeted financial sanctions are implemented in Hong Kong by the relevant regulation under the UN sanction Democratic People's Republic of Korea Regulation Cap 537AE as shown on the slide. Please note that it is an offense under Section 4 of the Weapons of Mass Destruction Control of Provision of Service Ordinance Cap 526 to provide any service to another person where he believes or suspects on reasonable grounds that those services may be connected to PF, including, for example, the lending of money or provision of other financial assistance. Licensees should ensure that they have an appropriate system to conduct name checks against all updated lists. Apart from screening customers against the current list of terrorist and sanctioned destinations as the establishment of business relationship, thereafter, as soon as practicable, when the new list of terrorist and sanctioned destinations are published, licensees should also screen their entire client base against the new lists. list of the sanctioned persons and entities, and list of names of persons designated as terrorists or terrorist associates specified under the UNAMO are available at the website of our company's registries, trust, and company service providers, as shown on this slide. For reporting suspicious transactions, the relevant legislations are set out on this slide. Mr. Michael Young from Hong Kong Police Force will give a presentation on the methods of money laundering and terrorist financing and suspicious terrorist reporting in the next session. So this concludes my presentation. May I now pass the time to Mr. Young? Thank you.